The idea of assigning a named person to every child in Scotland has been controversial since the start. The government hope it'll reduce cases of abuse and neglect. Those who've opposed the plan say it's a form of state intrusion into family life. After they took their case to the Supreme Court, John Swinney has now announced a consultation and a fresh look at the scheme, which now won't be rolled out until August next year. But will it change radically? Named person, the scheme that appoints a teacher or health visitor to every child in Scotland to monitor their well-being. It's been the subject of controversy and legal challenges. Earlier this year, the Supreme Court ruled that some provisions of the system were unlawful, citing concerns over information-sharing provisions which could breach the European Convention on Human Rights, specifically Article 8 and the right to privacy and family life. But judges also said that the principles of the scheme were legitimate and benign. Today, the Scottish Government announced a 3-month public consultation on changes to the scheme.
The Supreme Court judgment does not dilute our commitment, but it has required us to revise part of the legislation to ensure that it is compatible with the European Convention on Human Rights.
The Scottish Conservatives, the largest opposition party at Holyrood, want the scheme to be scrapped altogether.
Could the Deputy First Minister tell us if he believes that the Scottish Government made a mistake by making a move away from the term welfare, which can be defined in statutory terms, to the term well-being, which has no clear definition and which as a result has lowered the possible threshold of intervention from at significant risk of harm to any minor concern about the child?
I don't take the view that it should just be about welfare. I believe it should be about well-being because that's at the heart of Calvert, because that's what provides for the early intervention activity, but there has to be an appropriate threshold. And that is the issue which now has to be examined as part of the analysis that I have undertaken.
Scottish Labour, meanwhile, reiterated its support, but called on the government to remove 16 and 17-year-olds from the legislation.
To include them was a mistake. To many people, it seems absurd, given that a 16-year-old can vote, marry, work, pay tax, all as an adult.
I will give consideration to the issue that Mr Gray has raised because I have made clear in my statement that my determination is to proceed on this issue with the objective of building consensus and to building broad agreement around this provision.
The named person scheme was due to be rolled out at the end of last month. The Scottish Government now says it hopes to implement it by August 2017. It stands by the scheme, but will Parliament stand with it? Well, joining me now to discuss this from our Inverness studio is the Director of Care and Learning at Highland Council, Bill Alexander, and in Newcastle from the campaign group No to Named Persons is Simon Calvert. Good evening to you both, gentlemen. Simon Calvert, is this a welcome consultation?
Well, look, let's not gloss over the fact that the Supreme Court in July ruled that this scheme is a breach of the human rights of children, young persons and parents. That's a major condemnation of the policy that the government wanted and that the Scottish Parliament voted for in 2014. What the Supreme Court has done is it has ripped the heart out of the named person policy that the government wanted. The most important power that the named person was going to have was the power to grab and share private, sensitive information about children and their families almost at will. That is gone. That is history. And the other thing that the Supreme Court said was that the sort of insinuation that the parents had to do what the named person said or else, that also was said to risk breaching human rights. But with respect, we know all of this. So it's going to be a very different policy.
Indeed, we know all of this, and that is no doubt open to interpretation and how the people view the Supreme Court. Well, indeed, how people view the Supreme Court's ruling. But my question to you is, do you welcome this consultation?
Absolutely. Of course we welcome the consultation. It's quite right that parents and the public and professionals should be asked their opinions. It demonstrates that the initial government spin that the Supreme Court ruling was, just a kind of minor blip was clearly wrong. They're having to have a major consultation. They've got a huge amount of work to do if they're going to try and correct the defects. They've got a huge amount of work to do in rewriting this legislation, and they're going to need help.
Let me bring Bill Alexander in here. Is this the right way to proceed, the announcement from John Swinney today?
Well, I very much welcome the announcement today, Gary. I'm sorry to hear Simon still repeating myths and misconceptions. The Cabinet Secretary today called for consensus and a period of engagement to have an inclusive process. I'm pleased that the government didn't rush at this. I'm pleased that they took stock. They've certainly listened to children's charities and public agencies across Scotland, and John Swinney's statement today very much reflected that. We're not going to have a desktop exercise, a lawyer writing up new legislation somewhere in an office. We're going to have an inclusive process, engaging families, engaging children, and engaging practitioners, involving the Information Commissioner's Office and the Children's Commissioner. And that certainly is very welcome.
Let me ask Simon Calvert, if you contribute to this consultation, what would be the thrust of that contribution?
Well, we'll say that the government has a job to do, first of all, to look retrospectively at the data sharing that they've been encouraging across Scotland for the last 2 years now, to see where unlawful breaches of privacy have already taken place. And they've got to do everything they can, having spent so long encouraging this kind of unlawful data sharing, they've got to do everything they can to stamp it out. They've got to win the confidence of parents. And this the statement today was schizophrenic. On the one hand, they were admitting some of the big changes that they've got to make in the light of the Supreme Court ruling. On the other hand, they were trying to pretend that, that it was sort of business as usual. That has really led to some local authorities thinking that they can carry on as usual, and it's led to concern amongst parents. Parents were relieved when the Supreme Court issued their ruling, but then they were made anxious again by the kind of government spin.
Okay.
So it's important that the government engages with parents. They've talked to the same government-funded children's charities over and over for years. They should spend a lot more time actually engaging with parents.
Well, John Swinney made the point today that this will be a very wide-ranging consultation, but Bill Alexander, you've been running a similar scheme in the Highlands for some time. John Swinney referred to it today. Have you had to make changes since the Supreme Court ruling?
No, the Supreme Court ruling, and let's go back to that, talked about the information sharing provision in the Children and Young People's Act. That has not yet been commenced. The Supreme Court ruling was not critical of current practice, and indeed, as you've already said, the Supreme Court ruling said that not only was the aims of the named person service legitimate and benign, but it was an entirely reasonable measure to support early intervention to support children and families. So that's a process that's already in place across most of Scotland.
Are other changes necessary, perhaps taking 16 and 17-year-olds out of this legislation?
Well, the Cabinet Secretary today said that he would go away and consider that, and I think that's very helpful. There may be pros and cons, and a period of consultation will be very welcome. What is also very welcome is that we have in Scotland a suite of practice that are considered to be leading the way in Europe. Scotland's working with Scandinavia, we're working with Eastern Europe to put many of the practices within getting it right for every child, developed here in Scotland, into place in those countries. And if we haven't got the information sharing provisions right in the Children and Young People Act, then we should work with consensus, we should have an inclusive process to address that. Well,
Simon Calvert, as well as being part of this umbrella organisation, you're also part of the Christian Institute, one of the groups that funded the legal action in the first instance. Has your organisation got the best interest of children at heart in your opposition here, or is it ideological?
Well, what kind of question is that? Of course we do. I hope you can ask the same question of Mr. Alexander. Of course we do. We've always said that one of our main concerns about the named person scheme is it distracts the child protection system by, instead of focusing on the risk of significant harm to children, it tries to take that system and turn its attention to this sort of government-funded measure of happiness, this well-being test. And that's dangerous. It risks diverting resources and attention away from vulnerable and needy children. And so that's very serious. So, I resent the question. We have worked with a very wide range of people all across Scotland. There are 36,000 people that have signed our petition. We've worked with people from all kinds of backgrounds, all kinds of philosophies, who all share the same concern, that the named person scheme was badly drafted and counterproductive to child protection. And the Supreme Court has vindicated those concerns. Mr. Alexander has defended this policy to the hilt for 2 years. 2 years ago, almost to the day, he told his local paper that concerns about the European Convention on Human Rights were misguided. Well, he was wrong, and he owes people an apology.
Let me bring Bill Alexander back in. Firstly, if you want to apologise, feel free, but let's deal with some of the other issues as well that Simon Calvert raised there in terms of not bringing parents along with this whole proposition and diverting resources from those children that desperately need help.
Well, firstly, I think, as most people understand, the named person service was developed by parents and for parents. We introduced a range of reforms in children's services between 2006 and 2008, and it was parents who said, This isn't about social workers. This isn't about psychologists. This is actually about how we contact children's services to get advice about our child.
But with respect, it's not
Who
all
is
parents,
the
is it? You do
person-
have to acknowledge the point that Simon Calvert makes. There are parents who are genuinely concerned about this.
And if they are, it's because they've heard myths and misconceptions that we've heard again tonight. Teachers and health visitors care passionately about children's rights. They care passionately about human rights, and they care passionately about the well-being of children and families. I'm very sorry to hear Simon deriding the happiness of children. If Simon wasn't in Newcastle, he would perhaps have heard the report today that Childline have had over 900 calls from children in the last year who have had suicidal inclinations. Now, absolutely, the well-being of children must be at the heart of our concerns. That's why families asked us to develop the named person service. So if they had a worry, and if they
point of contact,
just a very
they
brief
asked for a
point,
named
Simon Calvert,
person that was responsive to them. But you backed a policy where it wasn't for parents; it was about parents. The government really needs to think very hard about whether it still wants to press ahead with a named person who has a statutory obligation to monitor the well-being of children according to government targets. We know what they mean, but because they mean things like, as their own leaflets say, named persons asking parents, do your kids get a say in what they watch on TV and how their rooms are decorated? Those are the examples the government gave of the kind of things the named person would do, and that's why parents don't want it.
Unfortunately, time is against us this evening, but thank you both very much indeed for joining us. Thank you both.